vacant, they are surrendered. They are surrendered to increase the sought after courses. We have to supply, my lord, computer software engineers for the demand. And, my lord, if the requirements are met, your lordship have never exercised jurisdiction under 136 constitution.
Well, this is very wrong what they are doing.
Completely not incorrect.
What is their objection?
Stop it.
First it was section 20.
Yes, first section 20, then go 14 out of 70 stopped. The High Court has exercised discretion.
56 given to them and we know who they gave to. And
Sir, I want to show you lordship something.
And Mr. Vedyanathan, what was the ground for giving the same benefit to other colleges?
Yes,
not
56.
Exactly.
Then appears in those areas colleges.
Yes.
And obviously closes
those areas.
the administration.
Yes.
Regions.
Regions.
Suppose you have 5 colleges. Same
Normally we wouldn't have permitted it, but it appears that
The same locality, no region.
people were singled out. They have AICT permission, they have university affiliation, AICT permission of June. And therefore, it's a calibrated, it's a calibrated audit by the division bench headed by the learned Chief Justice of the High Court. I think there was something more to it, why they were really excluded.
They asked the question, why to 56? The question was, why did you give it to 56?
Out of 56 are granted.
Similar are given.
These people are
The same area. They approach not different areas.
Same area. I would like your lordship to see yours for a second.
We'll leave it, I think. Thank you.
Deeply obliged.
The leases are for engines where both parties irrevocably choose English courts as the exclusive jurisdiction.
Both of the single judge and the division bench is to hand over possession of the engines to this French company, right?
Which is the final relief in a suit which is without jurisdiction. In breach of an exclusive jurisdiction clause, governing law is England and the leases are unstamped bullets.
An interlocutory order, why should be it?
Bullets, it grants kindly see the final relief in the suit is only one. It's not a money suit. The final relief is please hand over the engines. Bullets, the learned bullets division bench, bullets interferes with the single judge to say that the single judge could not have rejected the objection on jurisdiction, leaves it open for us to raise it. Because if we succeed, that was they had to approach the English courts. In the meantime, the engine stand returned. How do we undo that? Will that not be an order which is in breach of an agreement between the parties?
What you have to say, they are subject to an English judge.
I just want to show, let me show the lease itself. And can it be the law? Can it be the law? Just one moment, Dr. Singhi. Can it be the law, that the lease is unstamped? We raise the objection. Division bench says, doesn't matter if it's unstamped, it's a photocopy. If they had filed an original, we would have had to impound it. But since it's a photocopy, it can be gone into. Well, is this going to be the law laid down, Mullah? Just kindly see page 48. Well, that is the law. The leases are admittedly unstamped. Just kindly see page 48, Mullah, what the learned single judge says. Page 48, Mullah.
Yes.
Of the PDF, if my lords have.
Dr. Singhi, what do you have to say? Subject to
this kind of conduct. He is
Can I just find the age, Dr.
Can I answer my lord? I have right twice to answer my lord.
Yes.
39.1, just read the law. But I'm just reading 39.1 at page 50. I'm so sorry, page 50. This brings us to the other contention that since the lease agreements were not stamped according to provisions of the 1899 Act, they deserve. So you throw everything to the winds. Exclusive jurisdiction, English law you don't plead, you don't bother stamping, you approach the Delhi High Court. Mr. Rao, in our opinion, is right that impounding can be ordered only qua original, unstamped or deficiently stamped documents. Concededly, the engine lease agreements lodged with the suit actions, copies of the originals.
Don't open any paper. I have a chart here. You can see it at leisure. Give me just a minute. The man, who is petitioner here, files a consent order undertaking, or not undertaking, consents that he will pay me by schedule. He uses in just 2 months, August and September, my engines for 223 flights. He violates the consent order. He suffers concurrently single judge and division bench, honorable division benches. Now, he makes a statement on affidavit on 8th of August that I understand the seriousness of my consent. Today on that consent order, he owes me $6.08 million US. After 18 appearances and orders, one after the other, before single judge, before suit, after suit, division bench, not a word of objection. On the 18th time, a person who's not paying comes and says, engines are in Delhi, registered office is in Delhi, but it's an international arbitration because the governing law is foreign. This is not a subject matter going to the root jurisdiction issue. Today, the interim order is pay, you consent. Now see the chart for 2 minutes. Just see the chart for 2 minutes. This should not be encouraged. He's flying. And just see the chart for 30 seconds. This is shocking. This 30 seconds, Lordship. Conscience should be shocked. Just see the top. This is the consent order. I'm sorry. I have broken up the consent order. Just Pardiwala Messi, just Mishra Messi. The first part, mostly not complied. On the first, I'm not reading, Wallace.
Yes.
4 separate installments. Second part, 90% not complied. Today the amount is 6.09 million. All these 9 delicious issues of law.
My friends have told my lord. Well, it's not a money suit. Well, we tried.
Consent order.
Yes, consent order before.
And the consent order says if any of the payments set out above is missed by the defendant,
And Allah return the engines.
liable to ground the 3 engines and return them within 15 calendar days.
Pursuant to the consent order, my learned friend should have told my lords, it's not a money suit, but we paid them $8.66 million.
How much did you not pay them?
Well, it's 2.67 million was the shortfall. We said we just want up till 30th September to pay the balance. Mullets, we raised Mullet's territorial jurisdiction before the learned single judge. My lords have it at page 650. It's recorded, Mullets.
But when you
Mullets, kindly see our approach.
when you enter into a consent order, there's no issue.
But the
of-
consent order says unless there is an order to the contrary. And Mullets, when Mullets they press the suit, we are entitled to raise Mullets territorial jurisdiction. But kindly see our bona fides. I want to show our bona fides. I appreciate.
Consent order provides a consequence. You have not made full payment. They're entitled.
Mullets, the consequences unless there is an order to the contrary. Now, Mullets, kindly see our bona fides. Mullets, despite the infirmities in the suit,
Even today to pay the.
well, we are ready to pay, Mullets. We are ready to pay. In fact, Mullets, we are in talks with them to pay. Mullets, we are in talks with them to pay. We are ready to pay. That's always been our stand. Mullets, we have never been defiant or recalcitrant.
No, very.
Mullets, we are ready to pay even today. Mullets, this week, Mullets, this is a listed company, Mullets. It's not a fly-by-night operator. This week they have raised, Mullets, in a QIP, 3,000 crores, Mullets. It's notified to the stock exchange. We are in talks with them. We are ready
For
to pay.
18 months he has not paid me.
Kindly see our bona fide. Mullets, kindly see our bona fide just for 30 seconds. Just kindly see.
He says I'm going to raise funds to pay you.
Kindly see. Kindly see our bona fides, Mullets. Kindly see our bona fides. It won't help them, Mullets.
2023, 8th of July 23, not 24, 1 minute.
Mullets, their own plaint says, Mullets, exclusive jurisdiction is UK courts. Their own plaint at page 476 says so, Mullets. Is governed by English law. They don't plead English law. Mullets, division bench, Mullets, lays down law that if agreements are unstamped, if original, they can't be looked into, but if photocopies, they can be looked into. He says we will ignore, Mullets, ignore committee of courts, we will ignore exclusive jurisdiction. My lords have held in Man Roland.
Consent terms before the Delhi High Court.
Bought 18
But at least, Mullets, kindly see my bona fides. Before summons, Mullets, before summons, my friend should explain.
The commercial bargain, you don't comply with it, you have to return the engines.
Mullets, before summons, Mullets, I negotiate with them.
Left in the